Welcome to CRJ 211. This week we're taking a look at Chapter 17, which talks about the pretrial process. So this chapter looks at the pretrial stages in the criminal process with really an emphasis on the constitutional aspects of these types of proceedings. So due process of law requires that those that are accused of crimes have to be given fair notice of criminal charges and an adequate opportunity to contest those charges. So in petty offenses, such as minor misdemeanors, due process usually requires no more than that the accused be afforded a summary trial before a magistrate or a judge. So for felonies and major misdemeanors, in other words, in offenses where people are incarcerated, federal and state constitutional requirements impose more elaborate procedural requirements both at and before trial. Now, since most criminal trials are disposed of without trial, what happens during the pretrial process often is going to determine the outcome of a criminal case. Now, the main components of a pretrial process are, first, the initial appearance before a judge, second, the preliminary hearing or the grand jury proceedings, and then third, the arraignment. And each of these plays an important role in the determination of criminal cases. Now, during the process, judges consider various motions that are made by the defense and prosecution at certain pretrial hearings. As a result of that, pretrial procedures can either eliminate from the system cases where trial is not merited, or they could produce a plea of guilty or nolo contendere, or they could set the stage for a fair and orderly resolution of cases that is to proceed at trial. Now, given the relative infrequency of trials, because as we mentioned, the plea bargaining aspect, pretrial procedures take on very great importance in the day-to-day operation of the criminal justice system. Now, where a defendant pleads guilty or no contest, the nolo contendere, to an offense, there's a factual basis for the plea, and the court is satisfied that the plea has been entered voluntarily. The guilt can then be pronounced, and the process moves along to the sentencing stage. So after reading this chapter, you should be able to explain why most criminal cases don't go to trial, why the right to counsel is very important in the pretrial process, how are petty offenses such as traffic offenses disposed of through summary trials, what are the different elements of the pretrial process, what are some of the factors that determine whether a defendant will be granted certain pretrial release or remanded to the custody of a jail. What are the different mechanisms by which formal charges are brought? How does extradition work? Why is it necessary? What are the different types of pleas that a defendant may enter? What are some of the various pretrial motions employed by both defense and prosecution? Again, why is plea bargaining so prevalent, but at the same time it's controversial? What is meant by pretrial discovery, and how does that process work? And finally, what are the requirements for speedy trials in both federal and state courts? Next time, we'll take a look at Chapter 18, which looks at the actual criminal trial.